Hi guys, welcome back to Nairobi Legal. My name is Rogers Gerinji, and this video is a continuation of matrimonial property law in Kenya. By the end of this video, you must be in a position to have understood these 7 key objectives, meaning that you should be able to define what matrimonial property is. You must be in a position to know why the court does not automatically share matrimonial property at a 50% division. The other thing you need to understand is whether a spouse can actually be able to own property separately from the other partner. So these are the key objectives we set out to achieve, and by the end of this video, you must be in a position to have understood what does matrimonial property entail within the Republic of Kenya. When it comes to the definition of matrimonial property, Section 6 of the Matrimonial Property Act of Kenya provides that property that is jointly owned and acquired during the subsistence of a marriage becomes matrimonial property. So an example here would be that if a wife and a husband use their resources to build an apartment, or they buy out an apartment, that apartment becomes matrimonial property. The other thing we need to know is that a property that is registered in the joint names of parties qualifies to be considered matrimonial property should it be developed and acquired during the subsistence of a marriage. So this is the definition of matrimonial property. Basically, these are the things that you do together. It could be a home you built together as a husband and a wife. It could be an apartment that you've invested in as a husband and a wife during the course of your marriage. That amounts to matrimonial property. Now, as a family law student, you can consider reading this case. It brings out certain principles as far as matrimonial property is concerned in Kenya. The next question is that how does property become matrimonial property? Here the answer is that property that is acquired jointly during a marriage by either spouse contributing directly or indirectly towards its acquisition and development becomes matrimonial property. So what I mean here is that if a wife and a husband maybe choose to take a loan, and after getting that loan they buy a block of apartments, now that block of apartment becomes matrimonial property. And so the next thing is that if that block of apartment starts to bring in profits that are used to build more blocks of apartment, this forms a chain of matrimonial properties. So you see where we started. One single matrimonial property that you've invested in together starts to build, bring in profits, and then in the course of acquiring the profits, you end up coming up with more buildings and buildings across the city. All that forms a chain of matrimonial property. Remember, as far as the first initial matrimonial property is concerned, there can be both monetary and non-monetary contribution. A non-monetary contribution could be maybe the wife managing that property. It could be that someone has even chosen to leave their job to run the operations of that property so that it grows. The other thing is that we need to also appreciate that if it's a loan that you took with your wife, she can contribute towards the repayment of that loan as you contribute, meaning that in the process you're both making monetary contribution to that initial matrimonial property. When it comes to the reason why matrimonial property is not divided at a 50-50 share, the judge reasoned that if we made this a default rule, then it would create an opportunity for a fortune seeker to simply contract a marriage, sit back and relax, while the other partner invests and builds different properties. And in the course of that marriage, one party with such a terrible intention would then file for divorce and simply walk away with half the marital property. So in the case of FIDA versus the AG, this is how the judge reasoned. And he stated that even though Article 45(3) of the Constitution provides that partners in a marriage have equal rights during the marriage and after the marriage, that equality of rights does not transcend to matrimonial property. Now, can you imagine if we had a default rule in Kenya where it stated that upon divorce, partners are going to share the property 50-50, and then meaning that we'll have a man who sees a rich woman, walks into a marriage, he makes no monetary or non-monetary contribution to the investments of the rich woman, then that man would go ahead to distress the marriage, and wait to reap half of the marital property. This is a question of justice. It will be so oppressive to the spouse who makes the bigger contribution to simply see the other person walk away with 50% without actually showing any contribution they made to that property. So I think you get the reasoning why we don't have a default rule that matrimonial property is to be divided at a 50-50 rate. However, we need to appreciate that should evidence show that a wife or a husband contributed up to 50%, either in monetary or non-monetary ways, then the court has no reason to refuse to divide the property on a 50-50 share, but there has to be evidence to that. So that's why we don't have a default rule that matrimonial property has to be shared at a 50-50 rate. And so as a family law student, you need to appreciate that when a marriage comes to an end, partners must walk away with what they deserve, meaning that what one has contributed towards the acquisition of the matrimonial property is what that person is entitled to. Even as Section 7 of the Matrimonial Property Act of Kenya emphasizes, by providing that a party will walk out of his or her marriage and take away the entitlement to the matrimonial property based on what they had contributed towards the acquisition and development of that property. I think this is what now equality means, because we would have a situation whereby a young woman or a young man walks into a marriage knowing that someone has made it all, watch them without any contribution. 4 years down the road, they say, I no longer love you and I want a divorce. Then they walk away with 50% because the law says it's an automatic 50%. So this is the reasoning that the court looks at, and they emphasize that your entitlement to that matrimonial property should be based on the contribution that you've made. So consider reading these two cases to understand further the principles I'm trying to explain. Just to take you back to section 2 where we discussed about monetary and non-monetary contribution in the first video, there are certain instances where non-monetary contribution may be considered to never have taken place. Remember, we may have a situation whereby a husband or a wife is so uncooperative, so wasteful, so distant, they don't offer you companionship, they are very lazy, selfish, wasteful, meaning that they are not actually contributing to growing the home. So if it's a husband, they spend most of their time drinking, they are so rude, they do nothing towards developing the home. And the other spouse, who in this case a wife, goes ahead to invest in property, grow the home, provide for the family. In this case, you can clearly see that there is no non-monetary contribution from the husband. And this can work either way. It can be a wife, it can be a husband. In this case, you can be able to prove that in terms of non-monetary contribution, the spouse did nothing, and in terms of monetary contribution, they also did nothing. So upon divorce, you can even have a situation whereby a spouse walks out of a marriage with nothing, because there was no monetary contribution, there was no non-monetary contribution, and it's very possible. And this was expounded again in the case of FIDA versus the AG. Now, the next question we need to address is that when is matrimonial property divided? So normally this happens upon a divorce or dissolution of a marriage, as you can see here. When this happens, then matrimonial property will be divided based on the contribution you made towards its acquisition. The other thing you need to know is that how does the court arrive at a judgment for division of matrimonial property? So what happens is that the court will evaluate the evidence on the acquisition of each of the properties in dispute, and it will determine which property is matrimonial property and which property is non-matrimonial property. Now, once a property has been determined to be matrimonial property, according to Section 7 of the Matrimonial Property Act of Kenya, the division of that matrimonial property between the wife and the husband will be based on the respective contribution of these partners to the acquisition of that property. Just to link up the previous questions that we've addressed, as far as this case is concerned, remember this is a case that happened in Kenya and it's available online. So this case involved a couple that had bought their first property in 1965, and this first property became the incubator, so to speak, from which the couple's subsequent purchases were nurtured. Remember previously I told you if a husband and a wife come together to build their first block of apartments using their resources, and that block of apartments starts to bring in profits, and the profits are used to build several other blocks of apartments. That chain forms matrimonial properties. So in this particular case, the husband had actually procured a loan under his own name, but when it came to repayment of that loan, both the husband and the wife contributed towards the repayment of the loan, with the wife using her salary as well as the husband. Now, the wife also took the initiative to manage this farm, and so as far as this case was concerned, the fact that the woman had actually, or rather the wife had taken the trouble to pay back the loan that the husband had procured, confirmed that she had a clear interest in that property. So remember that if that first investment you make together, in terms of resources that you put together, if that investment starts to bring in income that is used to grow several other investments, that forms a chain of matrimonial properties. So these are some of the options that you can have as far as matrimonial property is concerned in Kenya. So maybe you can have a situation whereby the property is valued and then sold, and then the proceeds are shared between the parties based on the contribution that they have made to acquiring that property. You can also have an alternative whereby, let's say, a wife has a 60% interest in that property, the husband has 40%, and then parties agree that the wife will buy out the property interest of the husband, and in that case the husband will be paid. So these are some of the options that you can have when it comes to division of matrimonial property. Now, can a partner own his own property? Yes, it is possible that a partner can own his own property. You could have acquired property before marriage, meaning that that's your separate property, and you can consider looking at Section 6 of the Matrimonial Property Act of Kenya, Section 6.3, and Section 6.4 of the Matrimonial Property Act of Kenya. So meaning that you can also have investments that you've done where your partner is not involved. That's your separate property, because that is something you're doing for yourself. Maybe you're doing this with a team of other people. That doesn't form a part of matrimonial property. But as far as properties, so long as properties acquired in the course of a marriage, and both parties have acquired an interest in that property through contribution to the acquisition of that property, then that becomes matrimonial property. Now, in the next video, we're going to be talking about the elements of a valid marriage in Kenya. Please, if you haven't had a chance to subscribe. Thank you.